A very good afternoon to all my dear students. On behalf of Institute of Chartered Accountants of India, I once again welcome all of you for the last Chapter 3 of Partnership Act, that is registration and dissolution of firm. So good afternoon, Om, Pranati, Venkat Lakshmi, Parkriti, Aniket, Amit, Vedahi, Pavitra, Shalini. Very good. Mangal Pali has written, I have completed the homework. That's great. Definitely, Aniket, we will take up these sections 36 and 37 from the study as well. But I'm glad you have read them. Good afternoon, Varun, Purva, Bhumika, Anant, Avesh, Dhruv, all of you children. Suprava Bhattacharya, good afternoon. Oh, Srinathi, a very energetic good afternoon to you as well. So everybody is excited and waiting for today's lecture. So that's wonderful. Janvi, Pallavi, Deepika, Yagesh, Aditi, Vidisha, Shriya, all of you children. So I'm glad to know that you have revised the balance sections. Those were left. So we will try to wind up the chapter number 2, which was left somewhere in between. So I have certain MCQs also in Unit 3 for all of you today. So we'll try covering the MCQs also, which helps me to judge how much you have, learned or not. All right. So let's have a quick revision of what we did in the last lecture. Section 30 was absolutely clear. I hope no problem in rights and liabilities of minor. Even in the mock test paper, students, we'll try to see if time permits. We'll try to cover one of the descriptive questions from the mock. Otherwise, my humble request to all of you, please, in the last 2-3 examination question paper, question related to minor has come. Even the descriptive questions given after each chapter, they have all these kind of detailed study. Please do go through them. All right. So section 31, 32 was again admission of a partner. We have discussed in detail regarding retirement of partner. Section 32, a very important section. It tells you that you will be discharged only after you have given a public notice. Unless and until public notice is not given, you are held liable for all the liabilities of the firm. Now, partner ceases to be a member without bringing to his relation with other partners. So it has to retire, then you have to leave your relationship. So Vishnu Chandra versus Chandrika Prasad, Supreme Court judgment, students, I always tell all of you that don't leave a single line or a statement from the study material. It's very, very important that we should read each and every line. So none of you have raised a query. I was assuming you must have read about Vishnu Chandra case. Again, in this case law, it is completely held that it is not necessary to dissolve the business on your retirement. It says the partnership business will come to an end. Let's read it. It says if any partner wants to disassociate means to retire, then in a clause of partnership deed, which comprehends a situation where a partner wants to retire, the expression clearly indicates that the partnership business will not come to an end. So if there are 3 partners in the Supreme Court judgment, it was held, if there are 3 partners, Mr. A, B, and C, and one of the partner wants to retire, how he can retire? Either by giving notice in writing if it is partnership at will, or as per the agreement, or as per the partnership deed. So let's assume as per the partnership deed, he's retiring. Now it says B and C can still continue the business. It's not necessary that the other partners should also close the business. So retirement does not necessarily lead to dissolution. The remaining partners can continue the business. So mere retirement of a partner will not result in assignment of tenancy rights in favor of remaining partners, although the retiring partner ceases to have any right or interest. So the partner who is retiring ceases to have means he will not have any more interest in the business, but the other partners remaining partners can still continue the business that they want to do it in their own. And what is the liability of outgoing partner? Simply serve a public notice, otherwise you will be held liable. Section 33, students, I hope there are no doubts in expulsion of partnership. It's a very important section. Analysis of expulsion, section 33, you have to remember these 3 points. So let me quickly do an example number 14 with all of you. A, B, C are partners. They were carrying their business, and spouses of A and B fought on ladies' club on their personal issue. So now there are three partners, and two of the partners, spouses means उनकी wife. तो उनकी wife का आपस में झगड़ा हो जाता है और वो angry होकर कहते हैं कि अब हम B को expel कर देंगे. Okay, so A gets very angry and he go and tells C that, listen, we'll expel Mr. B from the business. Now, since we have already done in the last class how the partner can be expelled without reading the answer, I want to know from all of you whether they can expel a partner. They had three partners, spouses have a fight, A got angry, he convinced C to expel B. B was expelled without any notice from A and C. Considering the provisions, please tell me whether you can expel this partner or not. Send me your answers, students, and let me read how many of you have written, if any doubts. Om Gupta says, ma'am, homework done, so that's great. All right, will you explain incoming and outgoing, Mr. Parth? We are doing the same right now. Nishi Garg, I'm good, and I hope all of you are fine. Miss Durga, it's absolutely fine. Good afternoon, Sneha, Apurva, Priya Darshini, Saloni, all those who have just joined. So we are just discussing example 14. You have to send me the answers. Let me see how well my students have revised their task. Quickly send me the answers. No, ma'am, he cannot do that. So what's the reason? I also want to know the reason. Varun Verma. Manmeet saying you have to address these queries to admin. Partners died. Mangal Pali, we'll discuss about the death of the partner. First, you have to give me the answer for this one. Because it has to be in good faith. Very good, Namanpreet. Nishi Garg is saying yes, because of mutual agency. Expulsion has nothing to do with mutual agency. Why are you mentioning about mutual agency? I fail to understand. First, notice has to be given. Very good. Par Kirti Goel. Apurva, C cannot good. Apurva, Lavina, Navya, Bhumika, that's fine. Priya Darshini. It is not in good faith. So most of you have accepted. Yogesh, Amit, Ritu. What about the notice? All right. Many of you have said that it is not in the good faith. Why it is not in the good faith? But because, ma'am, there is a condition that the partner to be expelled must be served with a notice. And my dear students, in this question, we have not given any notice. They have specifically written that without any notice from A and C. उसको notice दिया ही नहीं, बताया ही नहीं कि हम आपको expel कर. So then it becomes mandatory. First of all, power of expulsion must be given in a contract. Secondly, majority of partners. So तीन partner है, दो agree कर रहे हैं, तो majority होगी ना. More than 50% is agree. And it has to be exercised in good faith. So in exam, first you will write down, this is the concern provision. All right. So you have to mention this is the concern provision. Then you have to give the facts of the case. If these conditions are not present, then expulsion cannot be done. However, test of good faith is required. So सबने वही answer दे दिया, ma'am. Test of good faith के according expulsion is not possible. But you have to answer me. What was the test of good faith over here? This is what I wanted to tell you. That the notice should be served. And second reason can be a quarrel between. बच्चे आपने पढ़ा ध्यान से क्वेश्चन सबने. A got angry. हुआ क्या है? Spouses of A and B की लड़ाई हुई है. जो A and B partners हैं, उनकी जो wife थी, वो ladies club में लड़ने लग गई, झगड़ा हो गया. Do you think it's a valid ground? First of all, we are into a partnership business, and our wives have a fight, and that's why we are closing down the business. So you have to tell the examiner why you are saying no. खाली no लिख कर आओगे तो बस half mark मिल जाएगा. 6 marks का question है. He expects an answer from you. All right. I understand you can't write the detailed answer, but you should have mentioned that no, ma'am, because number one, the test of good faith is not met. Why it is not met? I wanted to understand from you. You're all right. The test of good faith condition has not been met. Number one, the reason is not very valid. Number two, notice has not been given. चलो 1 minute के लिए मान भी लिया. कि चलो रीजन वैलिड है, बट नोटिस के बिना यू कैन नॉट अलाउ द पार्टनर टू एक्सपेल. ऑलराइट, सो इंसॉल्वेंसी ऑफ पार्टनर पे आ जाते हैं. सेक्शन 34, somebody has raised a doubt in section 34. Simply section 34 में ये flowchart study has made. You just simply have to refer to this. Nothing else I want you to read from the paragraphs. Neither you have to read this section, neither you have to read the analysis. Only and only this flowchart. And this is how I expect you to make your flowcharts. So expulsion of partner, 3 arrows. What conditions have to be there? After that, you can expel only if it is in good faith, notice has been served, and majority of partners are. So that is how creatively you have to study your law. Let's go through this. Section 34, insolvency. क्या कहते हैं? Number 1, insolvent partner एक बार declare हो गया, he cannot continue as a partner. Simple. Partner की तरह नहीं act कर सकते. He will be ceased to be a partner from the date of adjudication. Now, what is the meaning of order of adjudication? Insolvency का meaning आप सबको पता है. Insolvent means a person who is not able to pay off his liabilities. He doesn't have sufficient assets. So court passes an order of adjudication. His order of insolvency is made. So if he has given this order on 1st April 2023, then from this date, he will not be a partner in the firm anymore. The estate of insolvent partner is not liable for any acts done. So any acts done after 1st April 2023, when the court order has come, his property will not be held liable. So now this insolvent partner has been ceased to be a partner. He is no longer having the profits of the firm. No longer he will be liable for any of the liabilities of the firm. Also, firm is not liable for any of his acts. So this after 1st April 2023, if insolvent partner still continues to do the business and he has certain liabilities on his head, firm will also not be held liable. So neither he is liable to the firm after this order of adjudication, nor firm is held liable. Ordinarily, इंसॉल्वेंसी रिजल्ट्स इन डिसोल्यूशन. वो कहते हैं जनरली क्या होता है, जब भी कोई पार्टनर इंसॉल्वेंट होता है तो फर्म को डिसॉल्व कर दिया जाता है, बंद कर दिया जाता है. बट द पार्टनर्स आर कॉम्पिटेंट टू एग्री दैट द एडजुडिकेशन विल नॉट गिव राइट्स. अगेन एग्रीमेंट से हम कुछ भी कर सकते हैं. दैट इज द ब्यूटी ऑफ पार्टनरशिप. व्हाट इज द ब्यूटी ऑफ पार्टनरशिप? दैट वी कैन डू एनीथिंग बाय साइनिंग एन एग्रीमेंट. कॉन्ट्रैक्ट है ना भाई, एग्रीमेंट है. एलएलपी है तो कॉर्पोरेट स्टेटस है. वहां पे खाली एग्रीमेंट नहीं है, वहां पे आपको रजिस्ट्रार के पास भी जाना होगा. यहाँ पे बेनिफिट ऑफ एग्रीमेंट बहुत स्वीट है. वो कहते हैं जनरली तो डिसॉल्व हो जाएगी इंसॉल्वेंसी में, बट हरलीन मैम, वेदही एंड अनिकेत, इन्होंने एक फॉर्म बनाई, इन्होंने साइन करा, ओके वी विल नॉट डिसॉल्व द फॉर्म इवन ऑन इंसॉल्वेंसी. अब अगर कोई भी इंसॉल्वेंट डिक्लेयर होगा तो इनकी फॉर्म चलती रहेगी, इट विल नॉट गेट डिसॉल्व. इजी है. अब इजी लग रहा होगा, क्लियर हो गया. इंसॉल्वेंसी ऑल्सो गुड. So after that, now comes your deceased partner. Somebody was asking a question for deceased partner also. Let me have some water. So it says, deceased partner means when the partner has died. After the death of that partner, his estate will not be liable for any actions. Ab similarly, agar 1st April 23 ko one of the partner has died. Now, if the firm is doing any business, the property of that deceased partner cannot be utilized for paying off the liabilities. Let us understand from the example. X was a partner in a firm. Firm ordered goods in X's lifetime. X's lifetime means जब X जिंदा था तब firm ने goods order करे थे. But delivery was made after X's death. Now, X's estate will not be liable as a creditor can have a personal decree. Personal decree means filing a case. Personal case can be filed only against the surviving partners. Okay? A suit for goods sold would not lie against the representative. This is because there was no debt due in respect of the goods. Now, what is this meaning of line no debt due? He says when X was alive, goods were ordered. Very good, ma'am. Goods were ordered when he was alive. But delivery kab hua? After his death. So when does debt accrues? Have you done an account? When does your payment accrues? Once the delivery has been made, you write in your books that now the creditors are outstanding or the debtors are outstanding. You have to make the payment. So now the liability has arisen. लाइबिलिटी तो तभी अराइज हुई ना कि जब उसकी डेथ होने के बाद गुड्स आए तो फर्म की लाइबिलिटी बनी। अब वो कहता है जस्ट बिकॉज एक्स हैज डाइड therefore now his legal representatives cannot be held liable, only the remaining partners, surviving partners will be held liable. All right, clear ho gaya death of partner also? You can read this. Anyone has any doubts in example 15, you can ask. Otherwise, we'll move on section 36. Okay. Very good, all those who have written. Notice is must. That's good. Ishika Roy, we have just discussed about expulsion of partner, and that was the example number 13 that we did. Insolvency ka property sell kar sakte. Yes, Ayush Mishra, that is how the insolvent estates will, his property will be disposed of and liabilities will be paid off. Saurabh Bansal, we just now discussed if partner has become insolvent, generally the firm gets dissolved. But if you as partners have agreed that no, ma'am, we want to continue, we have made an agreement, then you can still continue. Bhumika Seni, what have you not understood in section 24? Please ask that. Okay, good. So now let's move forward to section number 36, that is rights of outgoing partner to carry on the business. Agreement in restraint of trade. Have you read section 27 of Indian Contract Act? What do you mean by agreement in restraint of trade? पहले तो आपको ये पता होना चाहिए. Oh, that's good. Crystal clear, huh? Nice. Okay, no worries, Sneha. All right, so please tell me, you have to answer me, what do you understand by agreement in restraint of trade? इस लाइन का मतलब क्या है इस वर्ड का? Okay. So agreements in restraint of trade, that means you're doing any trade, you're doing any business, and we are trying to restrict you. You must have read under Indian Contract Act section 27. It gives you whole of the agreements which are in restraint of trade, where you're putting certain restrictions. Now this agreement will be valid only if these restrictions imposed are reasonable. Reasonable means ये सही होनी चाहिए, genuine होनी चाहिए. Now section 36 clearly tells you, children, once you have left the firm, you cannot advertise or do the same business. You cannot use the same firm name. You cannot represent yourself as you're carrying on the business. And solicit the customers means to attract the customers. In case you want to open up the similar kind of business, first you have to leave that business as a partner. But again, you cannot within the certain limits or for the specified period, you cannot carry on the similar kind of business. A partner may make an agreement. अब कोई partner अगर A, B, C 3 partners हैं और A outgoing partner है, retire हो, ठीक है ना? अब जब A retire हो रहा है तो वो agreement करता है remaining partners के साथ, B and C के साथ, that look, I will not carry on the business like yours. For example, they were into sale and purchase of electrical appliances. So A tells them that I will also not do the same business of electrical appliances. Number one. Number two, he says, I will not do it within the specified period. Say for 5 years, next 5 years, I will not do the same business. Or number three, he says, I will not do the business within your local limits. So if your business is located in sector 17, so near sector 17, whatever area 14, 15, 16 is covered, I will not do the business within the 20 kilometers arena of the place where you're doing the business. Now such agreements will be valid only if these restrictions are reasonable. So certain restrictions are students imposed on the outgoing partner. Why do we put the restrictions to the outgoing partner? Because why do we put very good? Exercising a lawful profession. Good, Durga, Om, Anushka, Chanchal, Shriya, Mangal, Pali, Lavina, all those who have given the answers. Trade between alien enemy. Yes, that's correct. Vedant Sharma, excellent. Restricting someone from carrying out trade activities. So you all remember this. Similarly, partnership पे भी आप restrict कर सकते हो. होता क्या है कि आपके साथ किसी ने business करा as a partner. So now that person knows about that kind of, he values what kind of business he has been doing with you. He has learned certain trade secrets about your business. So now if he is retiring from the firm, you can impose a restriction that, look, don't open up a competing business with us within these limits. And examiner can ask you, can he impose certain restrictions? So you will simply write that yes, if the restrictions are reasonable, then definitely section 36 permits the partnership to impose restrictions on the outgoing part. Section 37 कुछ नहीं कहता है, वो simply बताता है कि once the partner ceases to be a partner and still his share of property and profits have not been given to him, then 6% per annum additional interest will be given to that partner. So any partner, either he has died or he's outgoing, he has retired or become insolvent, but his estate is being used. Estate means वो अपनी property उसकी अभी भी use हो रही है partnership business में, आपने पूरा उसका settlement अगर नहीं करा, तब कोई भी subsequent profits अगर firm earn करती है, तो उसमें से interest at the rate of 6% per annum will be given to this particular partner who has left the firm. All right, and the last section 38 is very, very important. Children, please read the examples 16 and 17. They are very simple. Okay, the same baat wohi karta hai ki you are entitled within trust once you have left if your share has not been given. Section 38 को very, very important mark कर लेना क्योंकि examiner का favorite है and 2 marks का question काफी बारी इसके ऊपर आ चुका है. What do you understand by revocation of continuing guarantee? तो एग्जाम के लिए आपने एज इट इज लर्न करना है, बट मैं आपको समझा देती हूँ सो दैट इट बिकम्स इजी फॉर यू टू लर्न. सो सेक्शन 38 सेज एनी कंटिन्यूइंग गारंटी गिवन टू अ फर्म in respect of the transactions of a firm will be revoked for all the future transactions from the date of any change in the constitution of the firm. Such constitution changes by death, retirement or introduction of a new part. So इसमें हमने 4 points, पहले इसको divide करोगे. Section 38 talks about number 1, continuing guarantee given to a firm. Number 2, for the future transactions. Number 3 will get revoked. Number 4, on the change of constitution of the firm. Number 5, this is how the firm's constitution changes. So what is the meaning of continuing guarantee? Let's do a very interesting example. Nishi Garg has borrowed 10,000 rupees from Saloni Sharma. So Nishi Garg ने Saloni Sharma से 10,000 rupees borrow करे. So Saloni was already known to me and Nishi is also known to me. So Saloni came to me and asked me that, ma'am, can I give 10,000 to Nishi Garg? Can you give me the guarantee that she will return? So I told Saloni, okay, listen, relax. I know Nishi Garg very well. She is my student and definitely she will pay your 10,000 rupees back. Now this statement that I have made, children, this is known as guarantee. आप किसी के लिए गारंटी दे रहे हो कि हाँ जी ये बंदा आपके पैसे लौटा देगा, या फिर आप इसके साथ बिजनेस कर लीजिए. I stand as a guarantor. He is a very good person. So such a kind of guarantee sometimes is given to a firm, or maybe the firm has given any guarantee for a third party. And it is a continuing guarantee, means for all the transactions. So if a firm goes and borrow loan from the bank for 10,000, so I give as a guarantee, okay, fine, you can borrow, firm will definitely pay back. Another month he wants to borrow 10,000. Another month he wants to borrow 20,000. So continuously I'm giving the guarantee. So that is a continuing guarantee. So now whenever the firm changes, for example, one of the partners died or new partner has been introduced, or if the partner has retired, the constitution of the firm changes, means पहले ABC थे, अब ABCDEF हो गए हैं partners. पहले ABCDE थे, अब 2 retire कर गए हैं तो ABC ही रह गए हैं. तो firm की जो constitution है कभी भी अगर change होती है, at that time whatever guarantee has been given will get revoked means will get cancelled for all the future transactions. अब जो मैंने गारंटी दी थी कि हाँ जी आप इनको 10,000 का लोन दे दो, 15,000 का दे दो, that will come to an end for the future transactions whenever a new partner is admitted or any partner is retired. So you can simply write down in your simple words that any continuing guarantee given to the firm will come to an end for all the future transactions whenever there is any death, retirement or introduction of new partner. Okay, and do go through all these summaries that are given over here. You can also write it down in your own points also. All right, and please do give it a fair reading about all these points and descriptive questions and MCQs given over here. You must read all these questions. Okay, let's quickly do one. Reconstitution of the firm takes place in case of what? Admission of a partner, expulsion, retirement, or all of the above. When does the constitution of the firm changes? हमने अभी discuss करा ना. So reconstitution, please read down question number 4 in front of the screen, in front of all of you. Don't cheat and look into the answers. Let me see who answers this first one. Question number 4. Yes, Anushka Rajput, that was absolutely correct. Please send me answers for question number 4. Vaidehi Goyal, if the outgoing partner fails to give the public notice, then he will be held liable for all the liabilities unless and until he gets his name removed from the firm. Okay, and if you use firm's name, then you'll have to bear the consequences because firm cannot suffer because of your mistake of giving the notice. 4D, all of the above is correct. Wonderful. All of you have given the correct answers. So now you know that even expulsion is covered for the change in the constitution. This is what I want to make you clear over here. So well done, students. Let's begin with the last chapter now, which we have to end today, the registration and dissolution of the firm. So now we have already discussed chapter number 1 and 2, how the partnership is made, how the rules are given, how the rights and duties have been described. We have also known that a partner by holding out comes into stage if he is representing himself. We have also discussed in detail about the expulsion of a partner, that you can suspend it if it is in the good faith. Now we are going to register the firm. How many of you think that firm registration is compulsory? All of you are correct, students. 4D was the correct answer. Wonderful. Do you think registration of firm is compulsory? Yes or no? Send me the answers. Is it compulsory to get the firm registered? Yes, Mangal Valley, then also the revocation will happen in case of any on the change in the constitution of the firm. But section 38 typically talks about the death, retirement, and introduction of new partner. Vaidehi Goyal is the first one to give the correct answer. No, ma'am, it is not compulsory. So registration of firm is not compulsory. Excellent. So all those who have said, Suryansh is saying yes, Naveen is saying yes, and Gautam is also saying yes. That means they don't know this. Aditi is also saying yes. Suraj is also saying yes. Oh my God. 50% of the class is saying yes. And Namanpreet, chapter padkar aaye, she has written that no, ma'am, it is not mandatory unless and until to avoid the conflicts. So that means you have read the chapter. Pranati has written, as per English law, it is compulsory. So she has also read the first page of the study material. Well done. Yes, company mein registration is compulsory. Excellent. Anushka, that's correct. Shalini S has written beautifully. Company mein registration is compulsory, not in case of partnership. Lavina, Sneha, you're also right. Suraj is absolutely correct. LLP registration is must. Good students. So all those who have written, no ma'am, registration is not compulsory. That's the correct answer. So now, but still, it says we will be discussing over here the modes of registration. How, if you want to get registered, how can you get yourself registered? So number one, registration is not compulsory. Number two, we will discuss if you want to get yourself registered, how you can get registered. So section 58, हम पूरा बात करेंगे कि फर्म को किस तरह से रजिस्टर्ड करा जा सकता है. वो कहते क्यों जरूरत है रजिस्टर करने के लिए? इसलिए जरूरत है. Consequences of non-registration means section 69 आपको टिपिकली बताएगा कि अगर फर्म रजिस्टर्ड नहीं हुई है तो उसे क्या क्या मुश्किल आ सकती है, क्या क्या डिफिकल्टीज आ सकती है. So in the first half of the chapter, we will be talking about the registration, how the registration has to be done, and what happens if the firm is not registered. And at the second half of the chapter, we will be discussing how to close the firm. अब हमने सब फॉर्म समझ ली, राइट्स ड्यूटीज कर लिया, रजिस्टर्ड भी कर ली. अब हम बंद कैसे करनी है, फॉर्म डिसॉल्व कैसे होती है. इन एट द एंड वी विल बी डिस्कसिंग डिसोल्यूशन ऑफ फॉर्म. So let us first get the firm registered. So for registration of the firm, we have to go to the registrar of firms. So Delhi will have their own registrar, Punjab will have their own registrar, Bombay में अगर कोई firm खुली है तो महाराष्ट्र registrar में जाना पड़ेगा. हर state का अपना एक registrar office होता है. So you have to file a statement stating all these points. So if, say for example, let's make it a little more interesting. So Sakshi Kumari, Pratima and Navya, they have decided to open up a firm. Sakshi, Navya and Pratima, they have decided to open up a firm. Now they will make an application. They will write the firm's name. First of all, they have to decide what will the name of the firm. So it can be SP. कौन था? Sakshi, Pratima and Navya. SP and Associates. We can name this firm. They have to decide where the business will be done. So they will write in the application, okay, we have decided to do the business in Delhi. So where in Delhi that place should be mentioned in the application. Name of place where the business will be carried out. So at times you can have different places for the offices. So where is your head office, where the business will actually be carried out. And what date the partners are joining. Very important. Why do you think we need to give the dates? Because partners are held liable from the date of joining the firm. So if I have joined the firm today, my name will come today. If Pratima joins it at a later date, her name will come on that date. Sakshi joined after 3 months, her name will come on that date. So whenever the partners have joined, the date should be given. Full name of all these 3 partners and their addresses has to be given. And duration of partnership. What is the meaning of duration of partnership? Whether it is a fixed partnership or it is a partnership at will. So you have to mention whether it is a fixed partnership or it is partnership at will. Both the things is important to discuss. Ms. Janvi, I hope you have enjoyed and understood Unit 2 and there are no doubts. Yes, Neha Gupta, all your comments are visible, everyone. So because at times it becomes difficult to read, okay? Yes, Ayush Mishra, you have to go to the state registrar, not to the central registrar. Okay, so this is the application under section 58 that you have to file with the registrar of firms. Now, what will the registrar do? Registrar will see that Sakshi's details are complete, Pratima details are complete, and Navya, all the 3 partners, they have submitted all their details. Yes, that's correct. Responsibility and liabilities. Now, pay attention, students, here. I'm not looking into your queries. So your firm's name is correct, place of business. He will just tally all your details that you have given. Everything is correct. So now once the registrar of firm is satisfied, then he will make an entry in the register. So registrar of firms के पास एक register पड़ा होता है firms का, जिसमें entry कर दी जाएगी. Okay, SPN Associates is now is a registered firm. So what he will do, if he is satisfied that all your points of section 58 are correct, number one, he has to be satisfied Number 2, he will make an entry in the register. And number 3, he will file that statement. And number 4, he will issue you a certificate of registration. Now, this certificate of registration has to be kept at every place of business where you do your business. जैसे एक GST नंबर हम आजकल लेकर आते हैं, इसी तरह से फॉर्म को सर्टिफिकेट ऑफ रजिस्ट्रेशन मिल जाता है कि अब आपकी फॉर्म रजिस्टर्ड है. So this is how that registration certificate looks like. For example, certificate of registration, the Indian Partnership Act 1932 is written. It is certified that the firm by name of Cargo Pack, with its head office at C18 neighboring complex, Mumbai, has duly been registered. तो इस तरह का वो देखने में होता है. डेट भी दी हुई है 24 फरवरी 2015 को ये रजिस्टर्ड हुआ था. Given under the hands under 24th February. So on this date, the firm got registered. So this is how the official document of registration, Form H, Rule 11, Rule 17, it looks like. Now, although you mentioned, ma'am, registration of form is not compulsory, but still we are understanding that how it can be registered. Why? Because there are certain benefits which are given to the form which is a registered form. So if examiner asks you, what do you write about the registration form? You will write 3 steps. Number 1, the compliance. Section 58 में जो compliance दी हुई है वो लिखनी है आपने. Number 2, recording of the statement in register. The registrar will be satisfied. He will find all the statements and he will file a registration certificate. He will give you a certificate of registration that yes, now your form is registered. So you can see the stamp, the thappa that you get on your form, that now it is a registered form. Now, why it is important? Why it is really necessary? So I will just show you from the study material, because all the points given in the study material are very, very important. Although I have briefed them up in the summary also. So let me just open the study for you. Here. So this is your new chapter, registration. So we have discussed modes of registration, section 58, consequences of non-registration. Now we are going to tell you that, first of all, section 58 is given over here. The very important line is, firm's name cannot contain these words. Crown, emperor, empress, imperial, king, queen, royal, ये सारे राजा रानी वाले नाम, वो कह रहे हैं ऐसे कोई भी नाम या फिर गवर्नमेंट की अप्रूवल वाले, स्टेट गवर्नमेंट, सेंट्रल गवर्नमेंट से रिलेटेड कोई भी वर्ड्स आप विदाउट अप्रूवल नहीं यूज कर सकते. यू हैव टू टेक द अप्रूवल ऑफ द स्टेट गवर्नमेंट if you want to use such firms names. For example, Pratima says, okay, we will name it, since we all three have opened, so Sakshi, Pratima, Navya, Queen Associates. So if you're putting such kind of words in your partnership business, firm's name, then you need to take the state's approval. And then now when the registrar is satisfied, he will file a registration certificate, and any late payment, late registration. So if you were to register and you have delayed in registering, then 58 subsection 1A simply tells you that 100 rupees per year will be the penalty. So if it is a kind of firm where it is very important to register and then you have not registered yourself, 100 rupees penalty has to be paid. All right. So section 69 is the major interesting section, which tells you that if the firm is not registered, then it will be not enjoying all these kind of benefits. So I give you 5 minutes. Let's take a small break over here and go through section 69. Also read the example given over here, and then we will discuss it in detail. So let's take a short break here. So I hope you all have gone through consequences, exceptions 3 to 5, no relief to partners. Definitely Varun, Sneha Singh, Sahana, we will discuss all these points. Sahana is asking why we cannot use those firms' name, because anything which is related to, that patronage of government, you cannot use it without government's permission. So all those kind of terms which are not legally allowed, you have to take the approval of the government in case you want to utilize any of them in your business firm name. Now let's move to section 69, and I have read many of you have written so many queries. So don't worry, we are anyways going to discuss section 69 in detail. Now, what does it try to tell you? It simply says that if your firm is not registered, then all these points become valid. You cannot file any civil court against a firm or against other co-parties. Neither you can file any action against a third party. No partner can file an action against other partner. Even setting off of claim, only up till ₹100 you are allowed to set off the claims. You cannot even set off the claims. However, third party can sue the firm. अब इसको in general समझते हैं, कहता क्या? आपकी firm अगर registered है, then if you want to take any action against the third party, then you can take any action. Who is the third party? Say, for example, you have supplied the goods to supplier, Mr. C, and he owes you ₹15,000. Now the due date has passed and the supplier has not yet paid you ₹15,000. And your firm wants to take an action against that supplier. So law says for taking an action against that supplier, you must be a registered firm. If you are not registered, so consequences of non-registration is, if you are not registered, you cannot take any action against the third party. In other words, सिर्फ आपने ये underline कर लेना है bold में and mark कर लेना अपनी books में. Only a registered firm can file a case against a third party, and the person suing must have been in the register of firms. Very interesting. ध्यान से सुनो. आप 4 partners हो, A, B, C and D. ठीक है ना? ये registered firm. They were a registered firm. E is a supplier who failed to make the payment. Can the firm ABCD take an action against E? Yes or no? I said ABCD are Harshita Pali, मैं हिंदी में ही समझा रही हूँ, but we have to use both the languages, okay? So आपको ये बताना है कि ABCD registered firm है. Can I take action against E means third party के against action ले सकते हैं या नहीं? Yes or no? All right, good, Bedahi. Answer me now, all of you. Taking so long to answer, students. Okay. Yes, ma'am, they can take an action because it's a registered firm. They can take an action against third party. Excellent. अब कहानी में twist लगते हैं. There is a partner, Mr. G, who joined the firm. So this is a registered firm from 1st April 2020. Now, Mr. G has joined the firm on 1st April 2023. Now, can this Mr. G also take an action against E? कोई problem तो नहीं है? It's a registered firm. Yes, Pathak Jignesh, definitely it plays a very important role. How you attempt your paper, how you write an answer, how neatly and beautifully you write, it definitely matters. Yes, it is a registered firm. So now also it is a registered firm. Can G also take an action? Okay, Om Gupta, you say no. Why? Why do you say no? Why G can't take an action against E? He is also part of registered firm. What do you think? Anything extra needs to be done? सोचो, बताओ. Many of you have said no, ma'am. Why no? Obviously, वो थोड़ा सा अभी हमने लाइन पढ़ी है तो पता लग रहा है कि मैम ने स्पेशल डेट्स दी हैं तो कुछ होगा. जी के नॉट. ओके, बट व्हाई? Okay, Naman, firm has been reconstituted. His name is not in the Vedant Sharma. Excellent. Fresh registration. Sneha Singh, it is needed. Very good. Excellent, children. Yes. Nishi says yes if can partner. No. So the correct answer is all those who have given ma'am a fresh registration be required. Give yourself a patting. Excellent answer. This is how you have to answer law papers. You have to think critically and answer legally. Whatever legal provisions are required, okay? You cannot just answer yes or no. You have to have a proper backup in your answers. All those who are answering yes, it makes me clear that you have not read the first page, second page fully. So it's okay. Anushka has played safe. She says yes only if his name is registered in the registrar forms. So that is also good to write कि मैंने disclaimer दे दिया कि अगर नाम है तो आपको simply ये बताना है कि first we have to register Mr. G also. His name should also be in the registered form. So fresh registration certificate is required. Then only he can take an action. So beautifully answered. This is what this line is trying to tell you. The person who is suing means person who is taking an action. His name must be there in the register of firms. जिनको अभी भी डाउट है, अभी एक केस स्टडी करेंगे, उसमें ये वाला पॉइंट अच्छे से क्लियर हो जाए. अब no relief to partners for set off of claim. So I, Harleen ma'am, has to pay to your firm 20,000 and you have to pay me 18,000. So law says you cannot say that only Harleen will pay you 2,000 balance. No, you cannot set off the claims. You cannot do the adjustment entries. You have to make your 18,000 payment to me and keep waiting. Whenever I want, I will pay you 20,000. So such a firm is not allowed to set off the claims. Only the setting off up till 100 rupees is allowed, but not beyond that. Okay, where any action is brought by third party, neither the firm nor the partner can claim any settlement. Aggrieved party cannot file an action against other party. Now, who is this aggrieved partner? Aggrieved partner means जिसको गुस्सा आया, जो लड़ रहे हैं आपके साथ. वो कहते हैं क्या वो action ले सकते हैं against the other party? No, he cannot file any action against the other party. All right. So for filing an action against the other partner, also you have to be a registered firm. Say for example, two partners are having a quarrel in the firm. So now he said, okay, I'll go and take a legal action. So listen, first get your firm registered. You are an unregistered firm. आप legally तो कहीं आपकी presence ही नहीं है, तो हमें क्या पता आप क्या कैसे legal action ले सकते हो. So only an unregistered firm cannot file any action against each other. However, the person can file an action for dissolution. But अगर आपको लग रहा है फर्म में बहुत झगड़े हैं, लड़ाई हो रही है, बन ही नहीं रही है पार्टनर्स की, then please go to the court and file a case for the dissolution of the firm. That is allowed. That can be done. All right. And in case of unregistered firm, any action can be brought by the third party. So in the same example, A, B, C, D were the firm and G was introduced. And you said, ma'am, it is unregistered. Yes, ma'am, it was unregistered. Can E still take action against that firm? It says yes. Third party can still take an action. थर्ड पार्टी को कोई जरूरत नहीं है कि आपकी फर्म रजिस्टर्ड है या अनरजिस्टर्ड है. थर्ड पार्टी आपके अगेंस्ट एक्शन ले सकती है. सो दिस इज व्हाट वी कॉल द एक्सेप्शंस टू द रूल ऑफ नॉन रजिस्ट्रेशन. दैट मींस थर्ड party can still sue the partners. Set off of claim is allowed for ₹100. Setting off of claim is allowed. Partners can file a case for the dissolution of firm. अभी हमने पढ़ा ऊपर कि yes ma'am, partners एक दूसरे के अगेंस्ट नहीं कर सकते, but for dissolution they can file a case. Power of an official assignee or courts to release the property. आपने ही मुझे बताया अभी कि मैम ऑफिशियल असाइनी जो होता है वो इंसॉल्वेंट के लिए अपॉइंट होता है, तो क्या उसकी प्रॉपर्टी को बेचा जा सकता है? Even if you are an unregistered firm, then also the official assignee can still release, means can sell off the property of insolvent partner and also file an action. Any proceedings by the legal representatives. Legal representatives means the partner who has died और उसके legal representatives जो हैं वो फिर भी एक्शन ले सकते हैं for the accounts of the firm or to release the property of the firm. So all these are the exceptions which are covered under the non-registration of the firm. They still hold the points valid. All right. So this is your example 1, which is a detailed case study given by the study material. It says A and company is a registered as partnership firm. So can we say A and company is registered firm? Yes, ma'am, it is a registered firm. A, B, C are the partners. Yes, A, B, C are the partners. A dies. Now, A has died. B and C want to take an action against X on behalf of A and company without fresh registration. Whether this suit is maintainable, please answer me, students. A and company एक registered firm है. अब A मर चुका है. A has died. Do they need to take a fresh registration to file an action against X, or they can do it like this only? Exactly, Anjali. 100 rupees is such a small amount that I have allowed. Yes, Ayush Mishra. Do we need the fresh registration? Yes or no? No, ma'am. Why? Because his name. Yes, they may have to know. No need of fresh registration, Amanpreet. So why fresh registration is not required? Because A's name was already there. He was already registered. Somebody has died. Somebody is not joining. Okay, so here fresh registration is not required. Whether the firm is registered, a suit can be filed by the remaining partners for any subsequent deal. It says where any death of partner is happening. Here you don't need a fresh registration. All right, all those who have written, yes, it's wrong, children. Listen now. It says the partner has died. So A to already registered tha na, A, B, C was a registered firm. So B and C can still take an action. Business where it is carried on after the death of a partner, any remaining partner can file an action without notifying, means without fresh registration. The remaining partners can take an action even if it is not registered again after the dissolution and no notice was given to the registrar. So please write it down. In case of a death of a partner, likho sab. I'll just write it down for you all. In case of a death of a partner, no fresh registration is required. ठीक है? However, if a new partner has joined the firm, then fresh registration certificate is required. All right, students. So let's understand. Now, what if B and C has taken a new partner D and now they want to file an action against X? So now what do you think? Now read this in the above example. In the above example, death of a partner, fresh registration is not required. But agar unhone ek new partner liya D, then can they take an action without fresh registration? Now answer. Akib Lodi, about the previous liabilities, definitely state of the insolvent partner will be held liable, but after the date of adjudication, any acts done by the firm, insolvent partner will not be held liable. All right, Akib, I hope this clarifies. Yes, fresh registration is needed. Excellent, students. Very well done. Because now D has to be involved as a partner, so all of you have answered correctly. So I hope this point is also now crystal clear. Death of a partner, no fresh registration. Admission of a partner, fresh registration will be required. Examiner can give you such kind of descriptive questions. So इसको ध्यान से पढ़ लेना, notes बना लेना और आज ही revise करना. Now let's come to a very interesting and one of my favorite topics, dissolution of firm. It says there are differences between dissolution of firm and dissolution of partnership. एक होता है हम फर्म को ही डिसॉल्व कर रहे हैं, पूरी की पूरी फर्म डिसकंटिन्यू हो रही है, बिजनेस नहीं करें। एक होता है डिसोल्यूशन ऑफ पार्टनरशिप। You, me, and Mr. D were partners. So A, B, C, and D were partners. Now this Mr. G is joining. You told me, ma'am, fresh registration will be required if it is a registered firm. But does my business comes to an end? It says partnership between A, B, C, D will get dissolved and A, B, C, D, G will now come into existence. But if the firm A, B, C, D wants to end the business, then it will be dissolution of firm. तो डिसोल्यूशन ऑफ फर्म होता है फर्म को पूरा का पूरा बंद कर देना, अब हम और कोई भी बिजनेस नहीं करेंगे, हमारा काम बंद हो रहा है। डिसोल्यूशन ऑफ पार्टनरशिप का मतलब होता है पार्टनर्स में चेंजेस आना। जब कोई पार्टनर रिटायर कर रहा है, इंसॉल्वेंट हो रहा है, डेथ हो रही है या एडमिशन हो रही है, तब चेंज इन द कॉन्स्टिट्यूशन ऑफ फर्म होता है। सेक्शन 17 में हमने जैसे पढ़ा, that time when the constitution of firm is being changed, then your firm will not get dissolved, only the partnership gets dissolved. Okay, so this is again one of the examiner's favorite questions. He can ask you the questions based on dissolution of firm and partnership. We have certain MCQs also, so let me just explain you these points of difference and then we will jump back to the MCQs. Section 39 says discontinuance of partnership between all the parties. Now see this puzzle that I've shown you, the crack in the wall. If you can see, not on the wall, on the floor. So this is typically a very beautiful picture which is trying to show now the partnership has come to an end. We are now separated. अब हमारे बीच में कुछ भी relationship नहीं रहा. Can you see the angry faces? Somebody's pinpointing, the body language of these people. They're not happy with each other. So law says if you're not happy, if you don't have mutual trust and confidence, better close the firm. If you have so much differences that the floor has got separated, means वो दिखा रहा है आपको पिक्चर में कि हमारे बीच में एक दरार आ गई है, अब हमारी बिल्कुल लड़ाई होती है, बनती नहीं है. So that means this is discontinuance of partnership between all the parties. This kind of dissolution is known as dissolution of firm. Firm ही बंद हो रही है, कुछ हमें एक दूसरे के साथ कोई relationship रखना ही नहीं. Then that dissolution is dissolution of firm. However, dissolution of partnership is only partners are coming and going and the firm still does the business. यहाँ पे जो दो लोग अलग अलग रास्ता दिखा रहे हैं कि मैं जा रहा हूँ, मैं इधर जा रहा हूँ, that means it is dissolution of firm. But this is difference between dissolution of firm and dissolution of partnership. And this is how I expect my students to write the points of differences. If ever in exam he asks you the differences, mark a table, make a nice table, underline the words, write it beautifully in points, any kind of differences. Difference between counter offer, cross offer, definition, example, 2 points. Difference between dissolution of firm, dissolution of partnership, points, example. I always attempt the paper, question paper beautifully and in such a kind of way. Okay, so let us quickly go through. Dissolution of firm means discontinuance of firm. Firm has 3 partners, A, B, C, D. Relation has ended between all of them. They are angry, they're disturbed, they're not liking each other. Firm gets dissolved. However, where only D is joining as a partner, then new partnership is made. This is only changes in the partners. Dissolution of partnership has happened. जब firm dissolve होती है तो आप क्या करते हो? Realization of assets and liabilities. Go back to your accounts. Remember accounts chapter, dissolution of firm. You will sell off the assets and pay off the liabilities. Winding up means closing of business is happening. In dissolution of partnership, you only revalue the assets. So revaluation of assets and liabilities happen. Firm may be dissolved by the order of the court. However, partnership is never dissolved by order of the court. Court will never come and tell you, look, please let Mr. D join the partnership, or I think A should now retire. Court will not intervene. But if you are fighting and not doing business in a good way, if you are having huge losses, if your firm is not running well, then court can order for the dissolution of firm. but court will never order for the dissolution of partnership. Dissolution of firm involves dissolution of partnership. However, partnership may or may not involve dissolution of firm. Dissolution of firm is the final closure of books. यहाँ पे सारी books of firm close हो रही है, but यहाँ पे final closure नहीं हो रहा है. यहाँ पे business चल रहा है and books of accounts still continue to remain the same. All right. So there are different modes of dissolution, but I think let us first do these important MCQs in front of you. So let us move to testing our knowledge, because after this we are left with a very, very small topic. Thank you, Sneha Singh. I'm happy that you enjoy the notes also. That's great. And all of those who have written clear now, wonderful. I'm glad. Partner by holding out is declared according to the express agreement, by giving notice in writing, with the consent of all partners, or when he represents himself as a partner. Please test your knowledge. Question number 1 in front of you. Answer me. What is the correct answer for question 1? Good, Anshuka Rajput. That's great. Dev Kumar is saying 1B. That's not correct. Why are you saying 1B? So 1D is the correct answer, children. Wonderful. All those who have answered 1D, that means they have revised chapter 1 of partnership. Great. 1D is the correct answer. Punjabi Asif and Dev Kumar, both of you are wrong. Navya, you are also wrong. Tanvi, you are also wrong. Others have sent the correct answer. Harshita, you're wrong. Ritu is also wrong. Children, read the question carefully. Partner by holding out becomes when he represents himself as a partner. Please revise section 28. ABC and Associates is an unregistered firm. This firm cannot claim set on, set off, set on and set off, or none of the above. Read carefully and then answer. बाकी सबने ठीक दिया है. सूरज, निशी, विंध्या, आशा, पार्थ, जानवी, all of you are correct. Shamya. 1D was the correct answer. Now answer for the second one. Please answer the second one. Good. Well done. Gautam Verma, why are you asking? Registration is needed for dissolution. Dissolving of the firm means you're ending the business. Registering means you are continuing the business and you are taking the benefits for the registration. Okay. As per the expected view, registration is complete when, please find out which is the correct answer. Read the question number 3 carefully and answer. Dhruv and Chanchal, you are wrong. Anushka, you are wrong. Very quickly you have answered third one. पढ़ा भी नहीं है आप लोगों ने और सीधा आंसर कर दिया. Please read the question carefully. Yes, Vidisha, when you keep revising, you tend to remember all the sections. That's true. Thank you. 3B. Okay, Amar correct, Tanshika correct, Varun, Shalini is correct. Very few of you have given correct answer. D is absolutely wrong answer. Court has nothing to do with the registration, children. Many of you see you have not even bothered to read. Now listen carefully. It says as per the accepted view means what is written in law. Registration is considered to be complete when Registrar files the statement and makes the entry in the register of firms. Section 59 अभी पढ़ा हमने. Section 59 में क्या लिखा था कि Section 58 has to be complied, all the application has to be made, and then registrar gets satisfied and he will make an entry. मैंने बताया भी था आपको, एक register of firms रखा होता है वहां पर, उसमें entry record कर दी जाती है कि yes, your firm is now registered. SVN Associates was now registered. Remember? साक्षी, प्रतिमा, नव्या जो हमने फॉर्म आज क्रिएट करी थी. So read the question carefully, children, before you answer it. Registration of the firm is compulsory, occasional, optional, none of the above. Answer me the fourth one. What is the correct answer for fourth one? Is it compulsory, optional? You already have discussed this with me. Somebody is still writing it's compulsory. I don't know why. 4B is the correct answer. Registration of firm is optional. Correct. Let's do one more. Reconstitution of the firm takes place. This we have just done. Okay, come to the sixth one. A and B are partners in the firm. The wife of A and B had a fight in club and B was expelled only on that basis. Is this expulsion justified? Yes or no? What do you think? Is this kind of expulsion justified? Yes or no? Excellent. 6B is the correct answer. We just discussed that expulsion has to be on a certain specified reason, having a good faith. And if you're just expelling a partner, number one, if it is not in good faith and without giving any notice to the person of being heard, then it will not be considered as a justified expulsion. All right. So just go through these points that we have just discussed and let's take a small break over here and then we'll continue and finish the chapter. Students, all of you have given the correct answers for the previous one. Let us complete the MCQs and then we'll start further. So the 7th MCQ is here in front of you. Minor as a partner can be made liable to outsiders. Yes or no? So minor can be admitted in the partnership for the benefits of the firm. Can we made him liable to the third parties? Yes or no? That was quite simple, and Saloni, Palak, quite quick. Yes is the correct answer. Well done. What is the time period for public notice to be given by minor for attaining majority? How long can you take for giving the public notice? Quickly answer. So all those who are answering 3 months, I fail to understand. What are you thinking? 6 months is the correct answer, students. 8C is the correct answer. Wonderful, all those who have given the correct answer. So within 6 months period, you have to decide whether you want to become a minor or you want to become a partner or not. And what happens if the failure to give the notice? If this particular minor, if he fails to give the notice, then what will happen? Will he become the partner or he will not be considered as partner? Yes, Jia Walia, I've read your answers. Correct, all of them. Srishti, 8A is not correct. 8C is the correct answer. Anshika, what you did not understand in question number 7? Question number 7 are you asking? Minor as a partner. What did you not understand? It says that whether the minor can be liable to outsiders. So the answer was no, minor is never held personally liable. All right. So now I've asked you, what will happen? Minor will be considered as a partner. Very good, Saloni. That's correct answer. So if ever he fails to give the public notice, then he will still be considered as a partner. And what happens when he becomes a partner after attaining majority? Can you tell me? If he fails to give the public notice and he is considered to be a partner, that's wonderful. Then what will happen to his rights and liabilities? Then he will be entitled to be liable for all the actions of the firm from the date of his joining the firm. However, his share of profits will remain the same. All right. So great. All those who have given well justified answers, that means you're revising and you're preparing. Okay. Let's move to dissolution of firm now. So I told you what is a dissolution of firm and what is dissolution of partnership. Firm can be dissolved without the order of court or by the order of court. Section 40 to 43, children, typically deals with the without the order of court. So where we made a partnership by agreement, it says section 40 simply tells you that firm can be dissolved by an agreement. Where it is compulsory, some reason has happened when it becomes immediately necessary to wind up the firm, then 41 will say compulsory dissolution. So when does the agreement, section 40 says the partnership was formed by an agreement. So you have simply written in the partnership deed that by agreement we can dissolve the firm. So now the firm can leads to the closure of your final accounts. You can close the business as and when the date is given. Section 41 is very interesting. It says firm was carrying on the business of trading in a particular chemical. And then the law was passed that now you cannot trade in this particular chemical. This particular drug has been banned by the government. So now if he still continues to deal, the business will become unlawful. So now we have to immediately, out of emergency, we have to dissolve the firm. तो 41 कहते हैं कई बारी सिचुएशन हमारे हाथ में नहीं है, हैपनिंग ऑफ एन इवेंट कुछ ऐसा हो गया है जिसकी वजह से योर पार्टनरशिप बिजनेस हैज बिकम अनलॉफुल और now you cannot continue the same partnership, so it has to be dissolved. You have to change the business. Section 42 is very, very interesting. It says on the expiry of term. When it says partnership gets dissolved on expiry of term means it is a fixed partnership. So fixed partnership है 2 साल के लिए करी थी. On the expiry of 2 years, this partnership will come to an end. Particular partnership. We have decided to do the partnership for a particular venture, that is 2 or 3 ventures. Now those ventures have completed, so this partnership will come to an end. By death of a partner, unless otherwise agreed. So if any of the partner has died, ordinarily it results into dissolution. If you have agreed, then it will continue. Insolvent, ordinarily it results into dissolution, or if you have agreed, then you can continue to it. So section 42 covers fixed partnership, particular partnership, death of a partner, and insolvency of a partner. All these 4 points are considered as contingencies. Contingencies means emergency. So if any emergency has arisen because of which the partnership needs to come to an end, so accordingly decision is taken. Section 43, partnership at will. हमने उस दिन भी डिस्कस करा था. Partnership at will क्या होती है? Where no fixed period has been determined. Here dissolution can happen by notice in writing. So there are 2 partners A and B. They decided to continue the firm, but they did not decide the term period. That is known as partnership at will. So A can communicate his interest of dissolution. A will write a notice in writing that look, from 1st April 2023, let's dissolve this firm. However, if on 1st April 2023, A communicates to B and he does not write on which date we should dissolve, then this particular date on which he is giving the notice will be considered as the date of dissolution. Number 1, he says that the date of dissolution should be given. So if I am sending a notice on 1st April 2023 that let's dissolve the firm from 1st September 2023. Then from which date the firm will get dissolved? Then the firm will get dissolved from 1st September. Point number 2, on 1st April 2023, I sent the letter that please let's dissolve the firm without mentioning any date. Then from 1st April 2023, the firm will get dissolved. Clear हो गया? Partnership at will में ये 2 important points है. Case study भी दे सकता है वो कभी आपको कि from which date the firm should be dissolved. And point number 44, section 44 are very, very detailed. We will do each and every point, clauses A to F from the study material when the court can dissolve the firm. Okay. But before that, there's a small story over here, dissolution of firm or only reconstituted. It says when partnership was for 6 years and after the same was stated to have by mutual consent, the said business with its assets and goodwill shall belong and carried by the continuing part. It says, can you reconstitute the firm after dissolution? So it says where the partnership is being reconstituted, that is dissolution of partnership. However, once the firm has been ended, then also the new business that you have formed, the new partners can still carry on the firm's business. So there is a difference between reconstitution and dissolution of firm. So now let's move to study material. All these points, short notes will be uploaded on the site also. You can refer to the presentation for short notes. But since we have to cover all the points from the study material, so now we'll just try to give it a fair reading of section 44, clauses A to F. Now children, dissolution of court means that now court is going to take a decision that when can the firm be dissolved. At times, if it's not a fixed partnership, if it's not a particular, so we have decided fixed partnership, section 41, 42 will become applicable. Particular partnership, 42 will become applicable. Partnership at will, 43 will become applicable. Partnership was by agreement, 40 will become applicable. But अगर कोर्ट को इंटरवीन करना है, कोर्ट ने डिसाइड करना है, तो सेक्शन 44 में ऐसे क्लॉजेस दिए गए जहां पे कोर्ट विल डिसॉल्व द फर्म एट अ सूट फाइल्ड बाय द पार्टनर. अब कोर्ट को कोई सपना तो आएगा नहीं कि किसी फर्म में कोई प्रॉब्लम हो रही है. सूट फाइल द पार्टनर मींस आपका कोई पार्टनर कोर्ट में आपके अगेंस्ट एक्शन लेने जाता है, तब कोर्ट उस फर्म को डिसॉल्व करे. ये जो क्लॉजेस A to F यहां दिए गए हैं, ये वो क्लॉजेस हैं जिनमें पार्टनर कोर्ट में जाकर एप्लीकेशन फाइल कर सकते. नंबर 1, अनसाउंड माइंड. अब कोई पार्टनर बिजनेस करते करते अनसाउंड माइंड का हो गया, हिज मेंटल स्टेट इज नॉट फाइन, then the court will dissolve the firm on a suit filed by other partners that see he has become insane partner, we cannot do business with him. If he's talking something really, he's not in a good mental condition, then court can intervene and the partnership can be dissolved. However, temporary sickness is no ground for dissolution. If one of the partners has fallen ill, he is suffering from viral, can you say that he has become insane? Can it be a ground for dissolution? Please tell me. Partnership remains. Yes, Punjabi Asif, if you have not dissolved it, partnership at will can continue till whatever time you want. Aditi is asking the meaning of adventures. It means the particular ventures for which you have decided to do the business. So it can be particular partnership that you have decided for 2-3 particular events we'll be doing the business, and then it comes to an end after those events. Tanisha Mishra, chapter 1, what are you trying to ask? Please write your question clearly. No, ma'am, that is a temporary sickness is the correct answer. Section 42, second point is not clear. Ayush Mishra, क्या नहीं समझ आया उसमें? Which second point, child? Section 42. When the firm is made for one or more adventures or undertaking, this is talking, Ayush, it is talking about the particular partnership. Remember in chapter 1, we discussed types of partnership, fixed partnership, particular partnership. So particular partnership is for doing a particular business. Say, for example, you have decided to open up an exhibition and you have entered into partnership for one day with someone. Now, after that one day, when that business is over, exhibition is over, your partnership will come to an end. Okay? Yes, Akshita, temporary sickness is not a ground for dissolution. That's great. Permanent incapacity. Now, one of the partners met with an accident and his whole body became paralyzed. Now, he is not able to do business at all. So, court can request for the dissolution of firm. What is the meaning of misconduct? Some of the partner is, not keeping the cash properly. He's trying to steal out the things. He's misbehaving with other partners. His conduct is not good. With regard to the nature of business, his behavior is not good. Then, any such misconduct means अगर आप ऐसी कोई भी गलती करते हैं, आपका behavior ठीक नहीं, then also court can request for the dissolution. Persistent breach of agreement. What is the meaning of breach? धोखा देना, breach करना, fulfill ना करना. Persistent means continuous. Now, one of the partners is again and again making mistakes. Embezzlement of cash छुपा लेना, चोरी कर लेना. Erroneous accounts means error वाले accounts बनाना, accounts में गलतियां करना. Holding more cash than allowed. ज़्यादा आपको allowed है 10,000, you're holding 15,000. Refusal to show the accounts. You're not showing the accounts. Other partners are saying, please show us the firm's accounts. In such cases, firm can request for the dissolution by the court. If one partner keeps erroneous accounts and omits to enter the receipts, continuous quarrels between the partners, destroying the mutual confidence, लड़ाई झगड़ा आपस में बन ही नहीं रही है, तो फिर firm will say, better you dissolve this firm. Court will say, you dissolve this firm, it's better to close this business. Transfer of interest. If any partners transfers his interest without asking other partners, in such a case also court can request for the dissolution. Continuous and perpetual losses. अब एक ABC associates हैं, they're doing business, but every year they're having losses. कभी 5,000 का, कभी 1 lakh का, कभी 2 lakh का loss ही हो रहा है. Perpetual means continuity. Then also the firm will order the dissolution. And these are the four very interesting, my favorite cases, where there's a deadlock in the management. अब कहते हैं just an equitable ground. ये लॉयर वाली लैंग्वेज में आ गया कि कानून को लगता है कि ये कानून की नजरों में फेयर है कि इस फॉर्म को बंद कर दिया जाए. वो कब लगेगा? जब डेडलॉक इन द मैनेजमेंट, मींस मैनेजमेंट ही नहीं पता किसको करनी है. ए कहता है नहीं नहीं मैं मैनेज करूंगा, बी कहता है नहीं मेरे को मैनेज करना है, सी कहते हैं आई डोंट लिसन टू यू, आई विल मैनेज. वो कहते हैं फॉर्म बंद कर दो, कोई कोई आप बिजनेस नहीं कर रहे हो, आप लड़ाई झगड़े कर. लॉस ऑफ सबसेंट्रम मींस आपका फेथ टूट गया. You don't have faith. You're not talking with each other. You don't even look at each other. So in such a case, it's better you close the business. So without the order of court 40 to 43, court's order 44, all these A to F you have to, A to G you have to learn. And it's very simple. First, we will complete the chapter. Then we will go to the queries. Consequences of dissolution, children. Dissolve होने के बाद होता क्या है? How the liabilities, now this is something which you have done in accounts very nicely. Liability for the acts of the partners done after dissolution. तो अगर after dissolution estate of deceased partner liable होगी या नहीं? No ma'am, it will not be liable. आप मेरे साथ MCQs में भी कर चुके हो. After the form has been dissolved, if partner has died, his estate is not liable for any of the acts done after his death. Section 45 says protect the third parties who had no notice of prior dissolution. But if no notice has been given, public notice has not been given, till that date, firm continues to be liable. However, a partner who has died, then that partner, his legal representatives will not be held liable. Other partners will be held liable until the date of public notice, and the partner who has died, his estate will not be liable after his death. X and Y carried on the business and executed on 1st December, but failed to give a public notice of dissolution. On 20th December, X borrowed in the firm's name. बहुत जरूरी है ये लाइन. वो कह रहे फर्म तो डिसॉल्व हो गई 1st December को, बट अभी 20th को उसने फर्म के नाम पे certain sum of money R से borrow करी. Y will also be held liable because public notice was not given. Simple. If public notice is not given, all the partners will be held liable for any further transaction done in the firm's name. However, insolvent, dominant, and deceased partner are not liable. Okay. So partners have the right to wound up after dissolution. Their rights will also come to an end. They have continuing authority for winding up. All of them can come forward and can decide for the winding up of the firm. What is important is section number 48. Mark कर लेना important. बहुत बारी examiner पूछता है what is the mode of settlement of partnership accounts. अब ये कुछ नहीं है, simply बता रहे हैं कि जब आपका business dissolve हो गया है तो आपने partnership A, B and C का accounts कैसे settle करने. So अगर तो आपके business में losses है बेटा, फिर तो losses first need to be paid out of the profits, out of the capital, and then partners will individually contribute. So whatever losses you have suffered in the firm, so losses need to be paid off. Number one, first from the profits. पढ़ा हुआ है आपने उसमें accounts में भी. First out of profits you will pay. आपने practical question करे हुए हैं ना बेटा इस पे. First out of profits, then out of capital, and balance will be paid by personal assets of the partner. ठीक है. So if the firm has any losses after dissolution, they will be paid out of the profits. So for example, there are 5 lakh losses and the profits of the business which are lying, that will be used. Any deficiencies in capitals have to be paid up in this format. However, the assets of the firm, okay, losses, liabilities तो हमने ऐसे पे कर दी, profits में से, capital में से, and फिर personal liability, personally पे करेंगे. But जो firm के assets हैं, वो क्या किसके लिए use होंगे? तो जो firm के assets हैं, वो पहले firm की liabilities के लिए use होंगे. You will first pay the liabilities of the firm to third parties. Then you will pay back the capital of the partners. After that, whatever partner has left the profits, they will be used, and the balance will be given to them in the profit sharing ratio. Okay, sometimes certain partner has bought in extra capital. So whatever partner ratably what is due to him on account of capital, that will be given. So some partner has bought certain furniture also from home. So now we are closing the business, dissolving it. First, everybody's share of capital will be given. Then that furniture, which the partner has bought, he will be given it back. Whatever is left will be divided among the partners in the profit sharing ratio. All right, students. And similarly, section 49 is also very interesting. Section 49 आपको क्या कहते हैं? Payment of firm's debts and separate debts. How will you pay off the firm's debt? Suppose firm के debts थे 10,000 rupees. And हमने एक पार्टनर को भी पैसा देना है, एडवांस करा था उसने लोन 1,000 rupees. तो कह रहे फर्म के जो डेट्स है पहले आप 10,000 rupees को पे करोगे फर्म के एसेट्स में से. Then if anything is left will be paid for the partners. So the property of the firm, point number 1 is firm's property will be used, applied means will be used for payment of firm's debt, and if there is surplus, then partners' debts will be paid. Point number 2, property of the partners will be used. अगर partner की property है A की, तो A की property will be used for paying of A's debts first, and if any surplus is left, you will use it for the payment of debts of the firm. So let me ask you a question. If rupees 1 lakh was left and firm's liability is 20,000 and A's liability, one of the partners, A is one of the partners, his liability is 86,000. How will you pay off these liabilities? Tell me. Payment of firm's debts. If firm has the liabilities, 1 lakh rupees is left. 1 lakh is the property of the firm. Firm's liability is 20,000 and A's personal liability is 86,000. How will you pay for it? Yes, Vidisha, modes of settlement of partnership, if it comes as straight away the same question, write all those points, losses wala and assets wala, points में divide करके लिख देना. Yes, first paid. Why are you writing 2 lakh Gaurav? 20,000 है बेटा. Yes, excellent. Komalpreet correct. Gaurav correct. Venkat Lakshmi, you are wrong. Partner personal assets. आपने ध्यान से सुना ही नहीं है. Venkat Lakshmi, please listen to the question carefully. 1 lakh has been left. So first you will pay off the firm's liabilities. That is 20,000 rupees. And balance, how much do you need to pay for A's liability? Answer me, students. Deepika, Prem, Jia Walia, Chanchal, Sneha, Sneha Singh, Sneha Namishkar, Saloni. All of you are correct, children. Well done. All of you have given the correct answers. There are others. Om Gupta, Ayush Mishra, Bindya, Apurva, Vedahi. All of you are correct. Very good. So 80,000 rupees A's liability will be paid because उससे ज़्यादा पैसे बचेंगे. सिमिलरली अगर ए की लाइबिलिटी है और ए की प्रॉपर्टी डिस्पोज ऑफ हो रही है तो पहले हम ए की प्रॉपर्टी को पे करेंगे. सपोज यहाँ पे अब इफ 1 lakh was A's asset, now firm's liability is 20,000 and A's liability is 86,000. In this case, you will first pay off 86,000 and whatever balance is left, I think around 14,000. 14,000 will be then used for paying the firm's liability. Okay. So with this, we come to an end of this chapter. So we have binded up partnership unit 1, 2, and 3 well on time. So now we have 10 minutes for queries. Any queries, any descriptive question, anything you want to ask, please feel free to ask. All right. Thank you, Jia Walia. Thank you, Arshita. Thank you, Vedahi. Anyone wants to ask anything, please ask me right now. And you have been very participative students. You keep answering in between. So that's wonderful. That is one way by which I come to know that my students have understood everything clearly. Okay, Aditi saying where you're doing any embezzlement means you're doing any kind of frauds in the partnership business. So, for example, me, Aditi, and Jia Walia, they are three partners, and Aditi always keeps certain cash in her own locker, and she is not telling us. So she's hiding it. She's doing any kind of fraud. In such a cases, it says embezzlement of cash is happening. You're trying to cheat the other parties. Then court can intervene and can close the firm. All right. Anshika Jain is asking example number 5. Which page are you asking, Anshika? Example number 5 हमने करा था ना अभी. Okay, we'll just discuss example 5. Let me check what other queries are coming. Om Gupta, residue means the balance. Residue का मतलब होता है जो balance बचा. Aniket, permanent incapacity means when you are not able to move. मतलब इतना ज्यादा उस बंदे की हालत खराब हो गई कि फिजिकल जैसे पैरालाइज्ड हो गया है, डिसेबिलिटी हो गई है. परमानेंट इनकैपेसिटी मींस वो चल ही नहीं सकता, बंदा कुछ काम नहीं कर सकता. ओके. चंचल, सेक्शन 46-47 में बेटा क्या नहीं समझ आया? इट सिंपली टेल्स यू द राइट्स ऑफ द पार्टनर, सरप्लस हैज टू बी डिस्ट्रीब्यूटेड. 46-47 आपको सिंपली बता रहे हैं जो भी प्रॉफिट्स बचेगा, जो भी रिमेनिंग एसेट्स लायबिलिटीज बचते हैं, पार्टनर्स हैव टू डिवाइड एंड डिस्ट्रीब्यूट अकॉर्डिंग टू देयर शेयर ऑफ प्रॉफिट्स. ओके. Jia Walia, I'll meet you for companies after this. Don't worry. Thank you, Sneha Singh. Thank you so much. And you all are also my favorite students. God bless you all. Section 49. Anushka is asking section 49. Section 49 we just did in detail. Once more, I'm telling you that first, if you're using firm's assets, suppose this is firm's asset. So whatever amount I'll get after selling this bottle will be used for paying the firm's liabilities and balance for personal liabilities. If it is A's asset, A की बॉटल है, अगर ये बिजनेस बंद हो रहा है तो इसको बेचकर जो भी पैसा आएगा पहले A की पर्सनल लायबिलिटीज पे होंगी, फिर फर्म. तो फर्म का एसेट फर्म की लायबिलिटीज, बैलेंस पार्टनर्स में. पार्टनर का एसेट पार्टनर की लायबिलिटीज एंड बैलेंस. ओके. Anshika, we'll just do example 5. Just give me 1 minute. Let me see if there are any more queries. Thank you, Venkat Lakshmi. Thank you so much. Yes, separate debts. Durga Ch-3, I hope you understood section 49 now. Bhumika Seni, section 24, 25, 26. We have already discussed them for liabilities. I'll just try to open it once again and discuss with you. Namanpreet, where you're transferring your interest to another person for any recovery of loans, the recovery of arrears means कोई टैक्स पे करने के लिए आपने कुछ भी ऐसा हेर फेर करा है, आपको दिखाना नहीं है कि रेवेन्यू में एरर दिखा रहे हो, then also court can intervene with your dissolution. Permanent incapacity, Aniket, I have told you, you have not still understood. Permanent incapacity means बंदे का एक्सीडेंट हो गया, उसकी बॉडी इतनी खराब हो गई है कि वो कुछ काम नहीं कर सकता. So permanently he is not able to do any kind of thing. He can't access the books. Whether he go ahead, he can access the books, but if he doesn't have the knowledge, then I told you that some of his uncle can come and see the books of accounts for his share of profits. Yes, Saloni, his asset can be used to pay off his liabilities first. Thank you, Bidisha De. Erroneous. Dhruv, erroneous means if there are any error in the accounts, you're not recording the entries properly. Now Suryansh has come up with example 6 also. दो examples छोड़े थे वो दो क्लास में, चलो कर लेते हैं. Thank you, Janvi Joshi. Thank you, Mr. Anand Goyal. Thank you, students. Okay, let's do first example 5 and 6 and then we'll see the further queries. Example number 5, children X and Y are partners sharing profit and losses equally and X died. It transpired that he contributed 6,60,000 towards the capital of the firm and Y has contributed only 40,000. तो X कितनी कैपिटल लाया था? 6,60,000. Y 40,000 लाया था, तो टोटल कैपिटल 7 लाख. अब एसेट्स कितने बचे हैं फर्म के? रुपीज 2 लाख. Now, first this 2 lakh will be utilized. How it has to be? Now it says how much is the deficiency. So 7 lakh was the capital and 2 lakh is only left. So this 5 lakh has to be shared equally by the partners. Or what did we discuss? वो कहते हैं losses कैसे share करोगे? कोई भी अगर अब loss हो गया ना, 7 लाख आप लेकर आए थे, सिर्फ आपके 2 लाख के एसेट बचे. So all these losses, first you'll try to take out of the profits, but वो है ही नहीं है कुछ आपका profits. So all this balance has to be borne equally by X and Y's estate. Y तो bear करेगा ही, but X की property में से लेंगे हम. मतलब जो 5 लाख बैलेंस है वो X and Y को इक्वल शेयर मिलेगा, उसका कंट्रीब्यूट करना पड़ेगा. Y पर्सनली पे करेगा एंड X की जो X तो रहा नहीं, he has died, तो X की प्रॉपर्टी में से वो चीज दी जाएगी. The surplus assets will be divided according to the respective interest. Similarly, the assets will be divided in proportion to the capital. Therefore, X's estate will be the main loser. क्योंकि X ज्यादा capital आया, तो उसकी capital में से ज्यादा हमें पैसा loss के लिए use करना पड़ेगा. Where is example number 6? We have already done example 5. Who is asking example 6? There is no example 6, child. All right. Aniket, to sum up the consequences of non-registration, if the firm is not registered, then that firm cannot file an action against the third party. Partners cannot take an action against each other. However, they can file for the dissolution of firm. Third party can still file an action against you. So this is basically the consequences of the non-registration. Suryansh, where are you talking about example 6? Which page number? Thank you, Jia Walia. Thank you so much. Question 1, substantrum. It means loss of faith, where you have lost interest and faith in each other. You're not trusting. One partner is saying, ki, I have bought the goods for 40,000. And other partner says, no, let me just check in the market. Is it really of 40,000? So you have lost faith in each other. Aapko trust, vishwas nahi. Tab bhi court dissolve kar sakta. Thank you, Chanchal, for writing no more queries. Punjabi SF, thank you so much for enjoying the session. On page number 3.27, Suryansh, are you talking about another chapter? It is that's why I'm asking na. Isme to hai hi nahi. It's in chapter 2, child. Okay, I will take up your query 3.27. Let me just see where it is. You should write a specific thing which you have not understood. It's very difficult, to take out the entire chapter and discuss. Example 6, we have already done this one. It is simply talking about the implied authority. Example 6 that you're asking, Suryansh. He's trying to tell you that where you have an implied authority, where you have borrowed any money, the lender knows that the firm has to repay the money. So anyone can be asked to repay that money. All right. And somebody who was asking typically about section 24 exception, it was, okay, let me just show it to you, all of you also. Somebody was asking about section 24 exception. So it simply tells you that in case of fraud, if any partner is doing, see, if one of the partner is having knowledge that there is a defective material or some problem, all the partners will be held liable. But if any partner is intentionally trying to do fraud, then only that respective partner will be held liable. So example 8 में आपने ये याद रखना है कि all the partners are liable because it was a genuine knowledge. Example 9 में आपने ये याद रखना है कि अगर इसमें fraud करा गया था, तो only that particular partner will be held liable. All right. All right. So I hope now these points are also very much clear. And with this, we come to an end of the session. I hope no more queries. We have discussed, Suryansh, I hope this example 6 was also clear. Thank you so much, students. See you all for the Companies Act. Revise your partnership. Go through the mock test papers. If still any doubts are left, when I meet you next Friday for companies, we'll try to solve the chapters. Please revise sale of goods and partnership nicely. I hope you'll do that. Thank you. Goodbye.